cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
I'm delighted to say that we've got a really good lawyer and a specialist expertise for you today while David Whiting takes a holiday. Instead, we've got Kathy Wilson from Kathy Wilson Legal. She's an accredited specialist in wills and estates, in aged care, anything to do with your superannuation, general property stuff as well. So really, pretty much can answer any question, not criminal matters this morning, but we rarely do that anyway. 1300 222 774. I've got some lines free. But if you've got questions about wills, estate, enduring powers of attorney, superannuation, retirement villages, aged care, any of that, Kathy is your person. Kathy Wilson, nice to see you again. Good morning.
Good morning, Virginia.
It's always nice when you come in off the bench.
Yeah. And it's such a nice day out, although I heard from the weather report it's going to change.
Okay, well, the mood often changes in here as well, depending on the questions that are asked. 1300 222 774. A couple of lines free. Quickly grab those and Kathy will help you out. Is there any news we need to share with anyone today?
Well, I know there was a discussion, an article in the newspaper just this morning about people cohabiting together because they can't afford to live alone. And of course, that has ramifications for anyone who is in a family law situation or in a deceased estate situation. Are they a partner? Are they not? And there's a lot of those cases coming up now.
Would you advise people to draw up some sort of agreement between them?
Yes, it's a good idea and keep it up to date.
Do you need to use a lawyer?
Well, if you're not cohabiting, if you're not in a relationship, no, but just have an agreement between yourself that says we're not in a relationship. That's enough for that purpose. But if you are in a relationship, it is a good idea if there is particularly if there's a disproportion in your circumstances, that you have what's known as a binding financial agreement or some other agreement that the court can take into account.
Is this to stop someone coming back later on and saying, actually, we were de facto, give me half of what you've got?
Yes.
Oh, gee.
And sometimes it's more than half.
Really?
Yes. So, there's quite a lot of cases now when a person passes away, particularly without a will, where the couple have separated, for example, or they cohabit, but particularly where they've separated. Of course, separation doesn't revoke a will. And so you can be separated and still be entitled under the will or under the laws of intestacy.
Gee, wow. Okay, that's something good to know because, of course, people are shacking up together just to save some money. It's too expensive, but be aware of what could flow or what someone might argue could flow from that arrangement. Okay, good to know. Let's get to our calls. Kylie in Long Forest. What would you like to ask, Kylie?
Hi, Kathy. Hi, Virginia. I'm one of three siblings. We're all executives for my father's estate. He died 3 years ago, and at that time we also became equal shareholders and directors in the family discretionary trust. After about a year, it was clear that my brothers didn't want to wind up the trust and sell its assets, but I did. And the problem then has come to that when there's been some expression of interest in the estate assets, my brothers have used sort of the power that they've got a majority vote in the trust to sort of get their, further their.
Yes, I understand the question you're asking. In relation to the trust, the person who has the absolute power is called an appointor, if there's one there, and sometimes a guardian. So you might be directors and shareholders, but go to the deed and see who the appointor is. That's the person with the power to control their shareholders and directors. The other option is to go to court. When people have trusts, they think they can do whatever they like. But actually there's been some decisions, particularly a case recently called Owies, a Court of Appeal decision that said you have to look at all the beneficiaries of the trust, not just consider your own interests, and you have to consider the interests of all those people. So for a long time, Virginia, people set up trusts as a tax vehicle, and what you essentially do is give your money to the trust, and the trust operates in a tax-regulated environment. The problem is that comes with rules. And the rules include the beneficiaries are entitled to be considered. So if it's not working and if they're being difficult in relation to the estate, you should see a lawyer and see about getting them removed.
Carly, is that possible?
Yes, it was
Yes.
obviously going to cause a lot of grief, but it is, I suppose, possible.
Could I tell you one thing that I found about these people that behave like that? If they're not consulting you and making joint decisions with you, it's going to cause grief at some point. You need to take by the horns and say, look, guys, you might not understand your obligations, but I want to keep this good, but...
That's interesting. So you're going to get grief anyway, is what you're saying.
Yeah.
So you may as well actually be proactive here and get the trust set up properly.
Yeah, get some advice. The Law Institute has accredited specialists. Now, what you need is an accredited specialist in wills and estates. If you ring the Law Institute, they have a terrific service. Make sure you get somebody who's got a specialist accreditation for your sort of problem.
That's great. Great advice. Carly, good luck. I hope that helps. So the Law Institute there is where you need to go. Brenda in Preston. Brenda, good morning. What's your question?
Good morning. I'm in a same-sex marriage, legally married. And my question is, do we need to have a will?
Yes. Everybody needs a will. People, please make a will. The court can't work out what you want to do if you don't have a will. So there's a generic set of rules.
Go on.
The rules of intestacy that determine what happens if you die without a will. There's still a high proportion of people that don't have one. I always say have a will. It might be a simple will. It might be a complicated will. Have a will.
But Brenda, are you assuming that because you're legally married, if one of you dies, all of the estate would automatically go to the other? Isn't that the case?
Good question.
Yep.
Is
that's
that what
exactly
you're considering?
right.
No, that's
Yep.
not the case. Jointly owned assets go by survivorship. So there's a survivorship rule that says if one dies and it's a jointly held asset, it goes to the other. If you own property, for example, as tenants in common as opposed to jointly, you have two distinct half shares and it goes according to the will of each person with their half share. With other assets, similarly, it doesn't automatically go to the others. So map out what you've got, make a will, appoint an executor and leave the money. If you want it to go to your partner, leave it to your partner. If you want it to go to your children from another relationship or somebody else, then put that in too and keep it up to date.
Brenda, are there children from other relationships?
Fur babies only.
They're
demanding little buggers.
Well, I tell you what, there's a lot of fights now over pets.
Yes, well, that's true. Exactly right. Yeah. Others may come for them. Brenda, get a will.
All right then, consider it done. Thank you.
Thanks so much. Nice to hear from you. And where you were saying that if there's no will in place,
yes,
and you've say got your tenants in common in relation to that property, then it's possible other people could come for it. Is that what you're saying?
Yeah. So a domestic partner, if you're a proper domestic partner, which is recognised as somebody that you've been in a relationship with for at least 2 years, or there's a child of that relationship, they get the first bite of the cherry, is the way I'll put it, and they've got a right to buy the house if there's not enough money in the estate to do it. So it depends on the value of the house. It's a little bit complicated the way the formula works if you've got a partner, but if there are no partners, then it goes to children. But if there's partners from 2 relationships, then it goes differently again. So it's important to get advice when you're doing those things, but people think sometimes that they don't have very much to leave, but you'll find you've got superannuation. You might have found, it's happened to one of my clients, that they won Tats Lotto just in the weekend that they died. So they went from having nothing to having a lot of money.
Seriously?
Yes.
Hang on, so who won Tats Lotto when?
So the deceased had bought a ticket in the Tats Lotto and won on the weekend that she passed away.
Was she alive to know that she won?
No.
Oh, my
She bought the ticket
goodness.
and died, and she didn't have a lot before that. So, yes.
I don't know what we conclude about buying tickets here, whether buying Tats tickets are killers.
I'm not encouraging it, no.
I shouldn't laugh, but that's an amazing story.
Certainly not. And another one where there was a racehorse winning.
After someone died?
Yes, after someone died. The horse raced on the Saturday and they won.
Wow. That's amazing. Trent in Wangaratta, what's your question? Good morning.
Yeah, look, I made my own will out, left everything to my daughter and son, absolute. And is that legal?
Well, it depends how you wrote it out. Can I suggest that you try a community legal centre? If you can't afford a lawyer, go to a community legal centre. Do you have a partner?
No, single.
Okay, and you've got 2 adult children?
Yes.
Yes, okay. So it's so long as you wrote it out properly and had it properly witnessed. Sometimes the wills can still be valid if they're not properly witnessed, but sometimes you'll find you're just as well to get a cheap, go to the community legal centre and just say, look, is this will valid? The other problem can be that you sound like you have capacity, but a lot of people make wills and say, I being of sound mind and understanding, and they're the very people that aren't of sound mind and understanding. And then and the other thing is that that circumstances change. So you can go to a general lawyer for something like that, and again, the Law Institute can appoint you to a general lawyer that can help out, or alternately try a community legal centre. Better to get someone check it. Don't have a fight afterwards about what it meant. It's not, it's not a lot of money.
Trent, does that help?
Yeah, just that I don't want the government and lawyers and that, asking for this,
Yeah,
that.
the government and lawyers are terrible people. The government won't take your money away if you've got next of kin. And lawyers, the little bit that you spend now for a simple will is going to potentially save you a lot of money later. So I'd suggest you find, just ring the Law Institute and see if there's someone who can do it relatively cheaply, if there's not much to be bothered about. If there's a lot, then you should be worried about it. Don't have a problem over the cost of getting a will done. It's a bit like getting a car serviced. It doesn't cost any more than that usually. If you've got a little old car, it won't cost much. If you've got a Mercedes, it'll cost you more.
Well, but then it's the investment that you make in order to protect the bigger investment, and it's worth it.
Absolutely.
Trent, good luck. We hope that helps. Who have we got here? Rick in Wonthaggi. Hi, Rick. Go ahead. I don't know if this is within our scheme of expertise, but let's see how we go, Rick.
Right, listen, my daughter, she's 22 now. She got scammed. She put $1,600 into someone's account. I don't know what the go is, but I want to know if she qualifies for criminal compensation or anything like that, because it's really had an effect on her. It's mashed her.
No, I've not known anyone to succeed in that way, but the bank, if she put money into the account, has the bank followed up? Because there's a couple of places you can report those things to. The police have a division that deals with those sorts of frauds, but your bank, her bank, is the first place to go, and there are a couple of websites that you can go to report the scam. But in terms of compensation for mental distress, I've not known of a case to happen to succeed in that way.
Right, so that'd be a precedent if that happened, yeah.
Well, I think it would be a struggle. I'd get some advice before I did that. I think that would be a real struggle. I've certainly not known of it to happen. And again, best place to start is going to be the Law Institute. They have a criminal law section that has some very good lawyers on it, and they can help you with those sorts of things.
Hope that's helpful. Nice to hear from you, Rick. Thanks so much. Louise in Caulfield. Hi, Louise. What's going on?
Oh, g'day, Kathy and Virginia. Thanks for taking my call. My father died about 6 months ago, and most of the estate went to my stepmother, who is now is overseas and will change her citizenship to another country, and she's going to sell up the estate. But within the small portion that we did inherit is a rental property, and none of the rent has been put into a trust account. It's all gone into her bank account, because they had joint accounts, and everything has now gone to my stepmother. The solicitor says that she will make sure that it is all sorted out in the end, but because of this sort of fairly messy will, we're going to have quite a few costs at the end in terms of stamp duty and land tax that will be payable early next year, and we won't have any funds to do that.
No, the land tax comes because you won't be occupying the property, but depending on how... did your dad occupy the property before he died?
No, it's
shop. Always been a rental. Okay, so it might have capital gains tax as well. So you've got a few issues around that. Look, I wouldn't be waiting. I don't know about this person. There are certainly people coming into marriages as second partners, and a lot of them are very good. There are some wonderful relationships, but there've been a number of relationships I've seen where somebody from overseas comes along, gets married, gets them to leave everything to them and leaves. I'd be looking also at your rights under the will. How long was your dad married to your stepmother?
30 years.
30 years? Yeah. Is it a big estate? Big estate?
$8.5 million.
Yeah, so I'd be saying to the lawyer, look...
We're getting by direct will we get about, between the three of us. And we supported my father through illness and
Yes.
Have been, I thought, good kids, pretty much lifelong. But I feel like we've been really sort of a little bit shortchanged because it's all going to be sold up. And
well, it doesn't have to be. You certainly have rights. Within 6 months of probate, you may be eligible to make a family provision claim. And even
if it's see, the thing is, everything was in joint names except for tenants in common.
So that's a problem. That's a problem in Victoria. In New South Wales, the law is different. They have notional estate provisions. In Victoria, if it was truly in joint names and not as tenants in common, then it goes by survivorship, and it's not available for a family provision claim. However, if your stepmother has been pocketing the rental, you can apply to the court for an order that she be removed as executor or passed over as executor, and one of the children appointed. Did Dad have capacity when he died?
Well, he changed his will very shortly before he died.
It's got all those hallmarks.
And they made sure that they went to a doctor to say that he had capacity. And look, the will. Well,
capacity is
not
the.
Change that much, except that the three kids we were going to be executors, and then it was changed.
Yeah,
but
okay.
I don't have a problem with my stepmom's been a really loyal, wonderful.
Right. Yes.
I just feel that we're going to have some costs to pay, no means to pay it. The solicitor says she will ensure that it's rectified, but I feel like the solicitor's doing the wrong thing, not making sure it's being put into a trust account.
Well, the solicitor can't. Is this the solicitor for her as executor? Look, I think your situation is a bit complicated, and I suggest you get some advice there. And if you're not sure about the lawyer you've been to, ring the Law Institute and ask for a referral to a specialist for another opinion. Sometimes that's worth doing. There are certainly avenues available to you. But I think it'd take a bit longer than I can do in this program.
It does sound complicated. And if it's an estate worth $8.5 million, it's worthwhile spending the money on the lawyer, isn't it? We're not talking about a couple of $100,000.
No, and there'll be capital gains tax issues and stamp duty issues, so get them all sorted out.
Yeah, and as Louise says, they'll have expenses but no means by which to pay them. So worth the investment there. Lee in Yarraville. Lee, good morning. What is your question?
Yes, good morning, Virginia and Kathy. Basically, I'm wanting to ask about how we move forward. My parents died over 2 years ago, and the executor has told us that he finally intends to renounce his role with the Supreme Court, and he's asking the public trustee to take over, which myself and at least two of my siblings disagree with. We haven't had a good experience with them when my mother was in aged care.
Yeah.
And there is...
Are you beneficiaries under the will?
Absolutely.
Okay, so there's a provision in the legislation, Section 15 of the Administration of Probate Act, that says that you can order your brother or have the court order your brother to bring the will into court and to pass over him as executor. That's probably going to be your fastest way of going about it. The state trustees can be good in some situations, but they are expensive. And they won't like me saying that, and I'm going to get a lot of hate mail. But they just are.
Well, they have that reputation. He's not a brother; he's an ex-husband of over 20 years ago.
Yeah.
And he has already expressed that he's applying to be. He's already renounced it and is going to the Supreme Court.
No. Well, if he's renounced it, then you're entitled to apply for what's called letters of administration with the will annexed as one of the beneficiaries under the estate. And I just want to say in relation to state trustees, before someone thinks about suing me, that is a subjective assessment, a personal assessment. It's not one necessarily held by the public in general. I've just found that in administrations of estates, if you can get somebody in the family to do it and you can cooperate, it's much better. You don't have those fees.
I don't think you're on your own with pointing out how expensive it can be. No one's saying they're not good at their job, but it's more the expense, and you're certainly not Robinson Crusoe there. Okay, so say that again. What letters do they apply for?
It's called letters of administration with the will annexed. So, again, if you get onto the Law Institute, ask them for, I think I'd probably, in your circumstance, go to an accredited specialist. And these are properly accredited through the Law Institute. They've gone through intense rigour and study and training to get where they are. and they're going to be the best person to help you. So it's called Letters of Administration with the Will annexed, and you do it on the basis that you're a beneficiary in the will.
Lee, I hope that's helpful. We've got Kim in Hastings. Go ahead, Kim.
Hi, yes. I'm phoning on behalf of my brother-in-law who's mentally and physically disabled. His brother's appointed by VCAT as his administrator only. VCAT ordered that the brother-in-law is capable of making his own life decisions and no guardianship. And the brother-in-law has received an inheritance from his parents. The will stated that there was 2 executors, his brother and equity trustees. Equity trustees have put the brother-in-law's money into a trust which they manage only. They just look for advice from the brother only. So our question is, because we went to equity trustees to say that BCAT have decided that the brother-in-law can make his own decisions, and they won't release any of the trust funds. They won't close it and release full funds.
It's not as simple as that, because, as you say, your brother-in-law has an administrator appointed. That means he can't manage his own. VCAT has determined, and they must determine that first, that he doesn't have capacity to manage his own financial affairs. The reason there's no guardian might be because there's no guardianship decision to be made. It mightn't be that he's capable of making guardianship decisions, but VCAT has to make the least restrictive powers, and they work very hard to do that. The members in the guardianship list are very focused on what orders are actually needed to be made. In relation to equity trustees, they've got a good reputation. They're well set up to do the job that they do. You might not like them, but they'll be doing what's in the best interests of your brother-in-law. I've no doubt about that. And if there's an inheritance in a trust under an estate, it doesn't fall within the realms of the financial matters covered by VCAT. If it's in a trust in the estate, if the money's left to him personally, then it is money that falls within the VCAT order.
Kim, I hope that's helpful.
Okay, so the funds have gone into a trust. So,
you know what? These trustee companies, they've got insurance, they've got proper committees, they work well. Yes, there's a fee, but you know what? You've got insurance. If something goes wrong, somebody will properly administer it. If something happens to your brother or the administrator, they're still there to continue, and it'll be because of the will.
I hope that's helpful, Kim.
It was very helpful.
Lovely.
Yeah, thank you. I just wanted to see what.
It's good to know and to check. Kathy, we've belted through a number of calls here. Good job, and many, many more calls that we could go to. Who knew? Well, I guess we did know that there were so many will and probate and estate issues out there. But thank you for your help. We'll see you again soon.
It's been a pleasure. I look forward to it. Thank you, Virginia.
Always a pleasure having you on board. Kathy Wilson there from Kathy Wilson Legal.